So this is just an enforcement overview and presentation. I will start off and then turn it over to Joshua. So I don't know if you want to position your chairs to the screen, or you can just listen to what I have to say. That's fine too. We're going to go over the complaint process, expert reviews, the investigation process, citation and fines, and the disciplinary process. Who does the board license and register? The board licenses psychologists, registered psychologists, and psychological assistants in California and has the authority to enforce the provisions of the laws and regulations relating to the practice of psychology. Who may file a complaint? Anyone who thinks a psychologist, registered psychologist, or psychological assistant has acted illegally, irresponsibly, or unprofessionally may file a complaint. What are the most common types of complaints the board receives? Sexual misconduct with a patient, violating the patient's confidentiality, providing services for which the individual has not been trained or licensed, drug abuse, unprofessional, unethical, or negligent acts. What types of complaints are outside the board's jurisdiction? The board has no authority over fee or billing disputes, personality conflicts, or persons who are licensed by other boards. Complaints that are not within the board's jurisdiction will be referred to the appropriate agency and the complainant will be notified. How are complaints filed? Complaints can be filed electronically on the board's website or downloaded and submitted by mail. What happens when a complaint is filed and complaint outcomes? Complainants are sent a letter acknowledging receipt of their complaint within 10 days of receipt. An enforcement analyst will be assigned to handle the case and perform a desk investigation by gathering the information necessary to review and evaluate the complaint. The information necessary may include patient records or written reports and a written response from the subject of the complaint. Once all of the information is gathered, the enforcement analyst will determine if the case should be closed or referred to an expert for review. If a case is referred to an expert, what next? If the review determines that the actions of the psychologist were not below the standard of care, the board has no authority to proceed and the complaint is closed. If the complaint involves a minor violation, it may be handled through a citation or an educational letter. If the complaint involves a more serious violation, it will be referred for formal investigation by a trained peace officer. Why is a case closed with no action? If the review determines that the actions of the psychologist were not below the standard of care, the board has no authority to proceed and the complaint is closed. Why is an educational letter issued? Cases involving no consumer harm can be resolved through an educational letter. An educational letter outlines the allegations, informs of the law, and warns the licensee if repeated, formal action could result. Why is a citation issued? Citation and fines are issued for less egregious violations or unlicensed practice. In cases where the statute of limitations prevents criminal prosecution for unlicensed practice or the local DA declines a case, a citation and fine may be issued. Why would a case be referred to the Health Quality Investigations Unit? If following the review by a board expert and it is determined that a serious violation of the laws and regulations has occurred, the case is referred to HQIU District Office for investigation. There are two types of investigations, desk and formal. Desk investigations are performed by an enforcement analyst or special investigator. The enforcement analyst or special investigator determines if the complaint falls within the board's jurisdiction. If the complaint involves care provided by a licensee, patient records and a response are obtained and reviewed by a psychology expert. If a minor violation has occurred, an educational letter or citation and fine could be issued. If a serious violation occurred, the complaint is referred for formal investigation. Formal investigations are performed by peace officers employed by the Division of Investigation, Health Quality Investigations Unit. Upon completion of the investigation, the case may be closed but retained for 1 year if no violation occurred, closed but retained for 5 years because the complaint is found to have merit but lacks sufficient evidence to take action, refer to the AG's office to determine whether to initiate disciplinary action, or refer to the local DA's office for criminal prosecution. Citation and fines are issued for minor violations of the laws and regulations that do not warrant formal disciplinary action. Minor violations include failure to provide patient records, practicing with an expired license, misleading advertising, and CE deficiencies. What happens during the disciplinary process? If the Attorney General's office determines the case meets the legal standard of clear and convincing evidence, the Deputy Attorney General drafts an accusation or statement of issues. The subject may request that an administrative hearing be scheduled so that he or she can contest the charges. Administrative hearings, stipulated settlements, and board vote. If the licensee contests the charges, the case is heard by an administrative law judge who drafts a proposed decision. If the charges were proven, the ALJ, in most cases, will recommend that disciplinary action be taken against the licensee, such as probation, suspension, or revocation. In most cases, the attorney for the licensee and the Deputy Attorney General work out what is called a stipulated settlement instead of holding a hearing. The licensee usually agrees to one or more of the allegations and agrees discipline is warranted. The board members review and vote on each disciplinary matter before the respondent is placed on probation, suspended, or revoked. Roles and responsibilities of, I'm sorry, Joshua, I think your slide is next.
Thank you. This is my one slide in the presentation. My name is Josh Tomplay. I work for the Attorney General's Office in the Health Quality Enforcement section. And I want to briefly review what HQE does for the board and solicit any questions you have, either during this public session or just as we have time afterward.
Oftentimes, we use a lot of acronyms in the context of state government, but everybody might not know what HQE means.
I'm
So
sorry.
if you explain.
Good question. We are the Health Quality Enforcement section, and that's one of the many pieces of the Attorney General's office. This particular piece is charged with enforcing health licensing laws for the various health agencies of the state. So HQE's role is to prosecute cases on behalf of the Board of Psychology and to assist with certain investigations. And by prosecute, I just mean to write the document that notifies licensees what they've been charged with, the accusation, to organize evidence to prove those charges, documents and witness testimony, and then to prosecute the case at hearing to try the case before an ALJ. So that's the bread and butter of what we do. We also assist with certain investigations where the board staff ask us to get involved early and help guide HQIU investigators. In addition, we manage any challenges to disciplinary decisions through writs or appeals. And last, we also we defend the board if the board is sued as a result of disciplinary actions. So that's the bulk of what we do, and you're welcome to ask me any questions when we have time afterwards, but that's just an overview of who we are at the Health Quality Enforcement section.
So are we going to wait for questions until after? Okay.
I'm Noreen Marks. I'm DCA counsel. DCA counsel's role with respect to the roles and responsibilities of the board are transactional. We assist with contracts, subpoenas, Public Record Act requests. We assist in the drafting of regulations and the shepherding through the regulations through the process, statutory interpretation, statutory drafting, and general legal opinions. We advise on the Open Meeting Act. We review the agendas before they're posted, and we generally assist the board with consumer protection issues. With respect to the enforcement side of the board's function, we sit in closed session to advise the board in its adjudicatory role. We do not get involved in the prosecutorial end of things. If we do, then different DCA counsel is brought in to advise the boards to assure that there's a separation of functions between the board's prosecutorial function and their adjudicatory function. And that is primarily what we do.